All right, if you're prepping for the Queensland bar, you know that procedure is, well, it's everything. It's the skeleton that holds your entire case together. Today, we're going to dig deep into one of the most fundamental tools in your kit, the subpoena. And we're going to focus specifically on Rule 414 of the Uniform Civil Procedure Rules.
So let's just start with the most basic question. You're building a case. You know there's a killer document out there or a witness whose testimony could flip the whole thing on its head. The problem? They aren't a party to the case, and they're definitely not volunteering to help. How do you get them or their documents into that courtroom? Well, the answer is the subpoena. It's how the court flexes its muscle.
And this is the absolute core of what we're talking about today, and it's a massive point for your exams. A subpoena isn't a friendly request, it's a command from the court. It has real power. But with that power comes a very serious responsibility. If you use it for the wrong reason or at the wrong time, it's not just a simple mistake. The courts have a name for it, an abusive process. And trust me, that is not a label you ever want attached to your name.
Okay, so here's our game plan. We'll start with the 3 basic types of subpoenas you can use. Then we'll walk through the nuts and bolts of actually getting one issued under Rule 414. After that, we hit the big one, the pre-trial discovery trap. This is where so many people get it wrong. Then we'll cover the practical side of serving different kinds of entities, and finally, what happens in court with compliance and objections. First up, let's get the language right. You can't just ask for a subpoena. You need to know which of the 3 types you're actually after. So, Rule 414, subsection 1 keeps it pretty simple. It lays out 3 distinct forms. First, you've got the subpoena for production. This forces someone to produce a document or some other physical thing. You'll hear the old Latin for this, duces tecum. Second is the subpoena to give evidence. This one compels a person to show up and testify. The Latin here is ad testificandum. And third, no surprises, is the combo meal, a subpoena for both production and to give evidence. 3 types, all under Rule 414. All right, so you know which type of subpoena you need. Now, how do you actually get the court to issue one? Let's get into the mechanics. The process is very specific, so you've got to follow the steps. First, under Rule 414, subsection 4, you have to file a request using Form 44. Next, under subsection 6, the registrar looks at your request and, if it's all in order, issues the subpoena with the court's seal. Then you serve it. But here's the bit that trips people up, a classic exam question. From subsection 7, you do not file the subpoena itself with the court. You only file the request for it. Get that one right. And remember, just because you ask doesn't mean you automatically get one. Rule 414, subsection 6, uses the word may. The registrar may issue the subpoena, and that little word may means they have discretion. As Justice McKenzie pointed out in that big case, latent contractors, if your request looks like you're trying to pull a fast one, like you're just fishing for documents, the registrar can and absolutely should refuse to issue it. Okay, this brings us to what is probably the single most important concept you need to master about subpoenas in Queensland. If you get this wrong, you are heading straight into that abuse of process territory we talked about. So picture this. You're in the early stages of a case. You don't have a trial date yet, but you know a third party has documents you desperately need to build your case. Can you just fire off a subpoena to get them? The answer, with very, very few exceptions, is a hard no. And here's why. It's all about using the right tool for the right job. The UCPR has 2 completely separate systems. A subpoena, under Rule 414, is for getting evidence at a hearing or trial. For getting documents before a trial, you have to use a different process, non-party disclosure, which you'll find in Chapter 7, Part 2. You simply cannot use a Rule 14 subpoena as a shortcut to get around the non-party disclosure rules. And here it is. This is the quote from latent contractors you need to burn into your memory. Justice McKenzie drew a massive line in the sand. He said, and I quote, "Any attempt henceforth to use a subpoena for the purpose of obtaining disclosure would be an abuse of process." It couldn't be clearer. Trying to use a subpoena for pretrial discovery isn't just a procedural hiccup, it's a fundamental misuse of the court's power. So is that rule from latent absolute? Well, for about 20 years, we pretty much thought so. But then a 2021 Court of Appeal case, Cohen v. Foley, added a little bit of nuance. The court confirmed that latent contractors is still the law, but it opened a tiny crack in the door for a very narrow exception. Imagine a super urgent situation where you think crucial documents are about to be shredded or destroyed. In that kind of extreme case, a subpoena might be okay. But, and this is a big but, for 99.9% of cases, the rule stands firm. Before trial, you use non-party disclosure. Okay, so you've navigated the abusive process minefield. You've got your sealed subpoena. Great. Now for the practical part. Who do you actually serve it on? The rules are different depending on who you're dealing with.
You have to be precise here. For a corporation, you address the subpoena to the company itself by its proper officer. And don't forget Rule 415, subsection 9, a company can't be forced to give evidence, only to produce documents. If you need work documents from an employee, you should usually serve the employer because they're the ones with legal control. And for an unincorporated association like a club, the Rutchford case tells us to serve the executive officer who actually has possession and control of the documents.
So the subpoena's been served. The day of the hearing arrives. The person shows up at court, documents in hand. What happens next isn't just one single event. It's a very careful, step-by-step process.
The starting point is non-negotiable. Rule 414, subsection 8 is crystal clear. A person who gets a subpoena must comply with it. Ignoring it is a very big deal and can be contempt of court. So you have to show up. But showing up doesn't mean you just hand everything over, no questions asked.
And this brings us to the famous three-step dance from the case of Wayne v. Hill. You absolutely need to know this. Step 1 is production. The witness obeys the subpoena by bringing the documents to the court, not to you. This is their chance to raise any objections like legal professional privilege. Step 2 is inspection. The judge then decides if the parties are allowed to see the documents. Just because they're at court doesn't mean you get an automatic right to look at them. The judge is the gatekeeper. And only after all that comes step 3, admission, where the documents are formally tendered and become part of the evidence in the case. So let's wrap this up. Mastering Rule 414 is all about one thing: getting the evidence to the courthouse door. It's a crucial, foundational skill. But once you get that door open, a whole new complex set of rules kicks in. Getting a document to the judge is one thing. Getting it actually admitted into evidence, well, that's a whole other battle and a topic for another day.